Welcome to the debate. Um, Imagine a zip tie seal on a ballot box. You know, when a state election official places that seal after an election, it isn't just a piece of plastic.
Right.
It is essentially a promise. It's a physical manifestation of the chain of custody. It basically says these votes are locked in space and time, and they're protected by the sovereign state that administered them.
Well, sure, but a seal is not like a magic, impenetrable shield against federal law. I mean, when there is probable cause that a federal crime has occurred, that seal can be legally broken by the very mechanisms of justice that are designed to, protect the broader republic.
Yeah, and that tension, that exact tension between state protection and federal intervention is exactly where we find ourselves today. Now, before we really dive into whether breaking that seal was legal, we need to set our ground rules. Please note that our analysis today is based strictly on the provided court filings, including Fulton County's Rule 41G motion and the amicus brief, along with Judge J.P. Boulet's ruling and associated news coverage. We are treating the source material as the factual record for our discussion.
And, we really are looking at a highly significant, truly extraordinary event today. We're talking about the FBI's execution of a criminal search warrant to seize over 600 boxes of original 2020 election records from Fulton County, Georgia.
Yeah, it's massive.
It really is. And, of course, we're also looking at the subsequent federal court ruling by U.S. District Judge J.P. Boulet, which actually allowed the Justice Department to retain those ballots.
Exactly. So the central question before us is this. Does the federal seizure and retention of these local election records represent a, constitutionally sound exercise of federal investigative power that withstands a legal challenge? Or does it constitute a dangerous federal overreach built on a misleading affidavit that callously disregards state sovereignty and voter privacy?
Right.
So I will be arguing that this seizure was built on a highly problematic affidavit, that it fundamentally violates Fourth Amendment protections, and that it severely undermines the constitutional delegation of election administration to the states.
And I will argue that under established legal standards, the court correctly ruled that the threshold for callous disregard of rights was just not met. Despite any flaws in the warrant, the federal government maintains a legitimate ongoing mandate to investigate potential violations of federal election law.
Okay, well, let me begin by laying out why this seizure is such an unprecedented intrusion into state election machinery. If you are listening at home, try to just picture the sheer volume of what we're discussing here.
Yeah, it's a lot of paper.
Right. We are talking about 656 boxes of original election records. These are the only original copies in existence. And the Department of Justice is claiming this, unqualified right to hold them indefinitely.
But they aren't just holding them in a vacuum, right? They are holding them under the explicit authority of a federal judge.
Right, but look at how they got that authority. The core of Fulton County's argument is that the FBI affidavit used to secure this warrant was deeply, deeply flawed. It relied on completely discredited theories, things like pristine ballots and missing ballot images.
Right, well...
And at the same time, the FBI agent entirely omitted the fact that state investigations, including the nonpartisan Seven Hills Strategies report, had already looked into all this and found zero evidence of fraud.
I hear you, but I think we really need to frame this around the exceedingly high legal bar that Fulton County had to clear to get these ballots back in the first place. They filed what is known as a Federal Rule of Criminal Procedure 41G motion.
Actually, let's pause for a second because, Rule 41G motion sounds incredibly dense.
Fair enough.
For anyone who doesn't spend their days reading federal rules of criminal procedure, Rule 41G is essentially the legal system's give it back button. It's what you use when you say the government took your property unlawfully, and you need it back right now, not years from now after a whole trial.
Exactly. It's an equitable remedy, and it's meant to force the government's hand during an ongoing investigation. But because it interrupts an active criminal probe, the legal standard is incredibly high. They have to show that the government acted with a callous disregard for constitutional rights. Now, I will acknowledge up front that Judge Boulet found the FBI's affidavit misleading and troubling.
Yeah, which is devastating.
It is a very serious judicial critique, absolutely. It's serious, but it is not automatically a constitutional violation. I mean, an imperfect or even a negligent affidavit does not equate to that strict legal standard of callous disregard. To reach that threshold, the deception basically has to be malicious and structural. And the court actually noted that the FBI agent included facts in the affidavit that both helped and hurt the government's case. That strongly indicates an absence of, malicious deception.
Yeah, I'm not sure providing a mix of facts excuses leaving out the most crucial ones, though.
Well, beyond the affidavit itself, to win a 41G motion, Fulton County has to demonstrate irreparable harm, and they simply cannot do that.
Why not?
Because the DOJ provided verified, high-quality digital copies of every single seized material. With those digital copies, the county can continue to fulfill its administrative and statutory duties. The county isn't paralyzed here.
Well, I have to disagree there. Providing a digital copy of a ballot does not repair the institutional damage caused by a flawed warrant. We really have to look at the specific evidence used to justify the seizure, because the integrity of the affidavit is inextricably linked to whether there was callous disregard. So let's look at the actual statutes the FBI cited. That's 52 U.S.C. sections 20701 and 20511.
Right, the Federal Election Record Retention Statutes.
Yes, but they govern misdemeanors for which the statute of limitations has already expired. You physically cannot prosecute conduct from the 2020 election under these statutes today. Furthermore, the affidavit completely failed to allege willfulness. And without alleging intent, simple human error in election administration is suddenly being treated as a federal crime. This strips the warrant of true probable cause.
Look, the legal threshold to force the return of property during an ongoing criminal investigation is intentionally set incredibly high for a reason.
Which is?
If the bar were low, every single target of a federal search warrant would immediately weaponize civil courts to halt criminal probes before they even begin. And the investigation here didn't just materialize out of thin air to harass Fulton County.
Well, it materialized out of deeply biased sources.
The affidavit cites 11 different witnesses claiming irregularities. We are talking about allegations of missing ballot images, duplicate ballots being counted, unsigned tabulator tapes. One data analyst witness claimed a computer program found duplicate ballots that disproportionately favored one candidate.
Right, but
when you have multiple witnesses alleging a failure to properly retain records or a deprivation of a fair tabulation, the federal government has a real mandate to investigate whether those deficiencies were the result of intentional criminal action.
I see why you think that, but let me give you a different perspective. When you look at those witness claims, you have to look at what the FBI agent deliberately chose to leave out of the affidavit. This entire investigation was predicated on a referral by Kurt Olson.
Right.
And he is a man who was previously sanctioned by multiple courts for making false statements about elections. The magistrate judge who signed the warrant was never told about those sanctions.
Omissions happen in affidavits, They're drafted quickly, often under a lot of pressure.
But these aren't just minor omissions. The affidavit omitted entirely innocent explanations for the alleged anomalies. Let's take the so-called pristine ballots that witnesses said looked completely unfolded. If you are a poll worker, sure, that might look suspicious. But an FBI investigator should absolutely know that pristine ballots are a natural, benign byproduct of overseas and military voting.
Right, because they're duplicated.
Exactly. Overseas voters often fax or email their ballots, or they mail them in folded up envelopes. Election workers literally have to duplicate those votes by hand onto flat, pristine scanner paper so the machines can read them. Or, take the delay in reporting recount results. It wasn't nefarious. It was a well-documented scanner programming error. So I have to ask you, if an affidavit omits entirely innocent explanations for the exact crimes it alleges, at what point does an omission transform a legal search into a structural Fourth Amendment violation?
It becomes a structural Fourth Amendment violation when the omissions are made with a reckless disregard for the truth. And this is key. When including those omitted facts would definitively destroy probable cause. This is the standard established under Franks v. Delaware.
Right, the Frank standard.
Yeah. The best way to think about the Franks standard is that a judge reviewing an affidavit post-seizure basically has to play Jenga with the warrant. If you pull out the misleading statements and you push the omitted, innocent explanations back in, does the whole tower of probable cause fall over? or does it stay standing? And Judge Booley determined it stayed standing.
Even with the pristine ballots totally explained away?
Yes, I mean, even if some ballots were pristine because of military duplication, it doesn't negate the witness who claimed the number of ballot images from the recount didn't reconcile with the ballots cast. Furthermore, a search warrant is an investigative tool. It is how the government gathers evidence to determine if the willfulness requirement of the statute is actually met. You don't need absolute proof of intent to get a warrant to go look for proof of intent. If ballot images were manipulated, willfulness could reasonably be inferred from the act itself.
But again, you are inferring willfulness for statutes where the limitations period has already lapsed. The latest any prosecutable conduct could have occurred under 52 U.S.C. 20511 was early 2021. If you are listening and wondering, why would the FBI seize boxes of ballots for a crime they legally can't prosecute anymore? Well, it's because a search warrant like this acts as a fishing net.
Okay, but
They are using an expired misdemeanor as probable cause to get into the room, basically hoping they find evidence of a larger unexpired conspiracy. If you cannot yield a criminal prosecution from the stated statutes, what is the legitimate federal law enforcement interest?
Finding out if a broader prosecutable conspiracy exists is a legitimate law enforcement interest.
But doing so creates a massive, broader institutional impact. Let's transition to what actually happens when those boxes are taken. By physically removing the original ballots, the federal government has broken the chain of custody. When the DOJ puts those physical ballots in a truck and drives away, they aren't just taking evidence, they are literally taking Georgia's ability to run its own state audits.
They left digital copies.
Digital copies do not satisfy the evidentiary rules for state proceedings. This effectively ended pending state civil proceedings. There were ongoing investigations by the Georgia State Election Board. There were cases before Fulton Superior Court Judge McBurney. By taking the physical paper, the state judiciary lost the ability to govern its own records.
I understand the frustration there, but
This has profound 10th Amendment implications. The Constitution delegates the administration of elections to the states. When the federal government kicks down the door of a county election hub and strips it of the very original records it needs to prove the integrity of its election against public accusations, it severely compromises state sovereignty.
I'm sorry, but I just don't buy that. Let me tell you why. First, let's look at the legal posture Fulton County adopted to bring this suit in the first place. To get into federal court, they invoked what is called corporate entity standing under the Fourth Amendment to challenge the seizure.
Meaning they sued as an institution, not as individual people?
Right, but you can't have your cake and eat it too. The law is crystal clear. If a county or a corporate entity claims Fourth Amendment protections against unreasonable searches, they are simultaneously admitting they are subject to lawful federal search warrants. You cannot claim the protection of the amendment while claiming absolute immunity from its execution.
Well, I don't think anyone is claiming absolute immunity. We are claiming the execution here was deeply destructive to state functions.
But the idea that a federal warrant trampling on a state civil proceeding violates the 10th Amendment kind of ignores how federal law enforcement operates every single day. Parallel civil and criminal investigations are completely standard. Think about it. If a local mayor's office is being investigated for federal corruption, the FBI doesn't politely wait for the city council's civil courts to finish their internal audits before securing evidence.
Yeah, but
They go in and get it. The Supremacy Clause of the Constitution ensures that federal criminal investigations can proceed, even if they temporarily inconvenience state administrative processes.
inconvenience is a rather mild word for severing a sovereign state from its own historical record. This isn't just a corrupt mayor. This is the mechanism of democracy itself. But the impact isn't just abstract or institutional. It is deeply personal for the citizens of Fulton County. Let's look at the very real-world consequences of the DOJ retaining these records, specifically concerning voter privacy and the aggressive expansion of this probe.
yeah, the amicus briefs focused heavily on this.
They did, and for good reason. The amicus brief filed by Georgia First and the ACLU highlights profound privacy concerns. These 656 boxes don't just contain anonymous vote counts on thermal paper. They contain highly sensitive, unredacted data.
Right.
We're talking voter rolls with social security numbers, driver's license numbers, dates of birth, and personal signatures on absentee envelopes. All of this is now centralized in federal hands without any protective order dictating how it is secured.
Look, I absolutely understand the sensitivity of the data. No one wants their social security number floating around. But we have to remember that federal investigators routinely handle classified, proprietary, and highly personal information in almost every white-collar or public corruption case they pursue. The FBI isn't careless with this material. They operate under strict internal protocols regarding the dissemination of evidence gathered under a grand jury or a search warrant.
But look at how the investigation is behaving right now. We recently saw a subpoena from interim U.S. Attorney Dan Bishop in North Carolina. He wasn't just asking for ballot images. He was demanding the personal contact information, names, home addresses, personal phone numbers, and emails of thousands of 2020 poll workers from Fulton County.
He's gathering witness information.
When you pair a sweeping, legally dubious seizure of private voter data with federal subpoenas targeting the private contact information of local, everyday election volunteers, it stops looking like a standard investigation. As the ACLU pointed out, the centralization of confidential information has a massive chilling effect on voter registration and poll worker participation.
How so?
Well, if you are a citizen volunteering to scan ballots for $15 an hour, and you know the federal government might seize your personal information years later based on an expired misdemeanor statute, you are going to stay home. It demonstrates a pattern of political harassment and intimidation. Without a protective order mandating how this data is stored, who can access it, and exactly when it must be destroyed, the risk of this data being misused or leaked is severe.
I certainly acknowledge the privacy concerns raised by the amicus briefs. Voter confidence is essential, and people need to feel safe participating in the process. However, the risk to voter privacy or the chilling effect on poll workers is, at this stage, legally speculative in the context of a Rule 41G motion.
Speculative? The subpoena for their home addresses is a matter of record.
That the subpoena is real, yes. But Judge Boley was bound by the record before him regarding the misuse of data, and he explicitly noted that no public disclosure or misuse of the seized materials had been proven by the county. Furthermore, regarding Dan Bishop's subpoena for poll worker information, it is entirely routine for federal prosecutors to seek the contact information of potential witnesses to an alleged crime. If you are investigating the tabulation process, you must speak to the people who physically operated the tabulators.
But pulling thousands of names?
To assume that a subpoena for witness contact information is inherently political harassment requires assuming bad faith on the part of the federal prosecutors. And a federal judge just cannot do that without hard empirical evidence. If Fulton County legitimately fears data misuse, the proper legal remedy is to file for specific protective orders regarding the data handling. The remedy is not to demand the wholesale return of the evidence, which would effectively terminate the federal investigation entirely.
I'll grant you that filing for a protective order is a standard remedy, but they did ask for the return and, alternatively, a protective order, precisely because the original seizure was so fundamentally tainted from the jump.
And the judge ruled the threshold for return wasn't met.
Right. Which brings us to the crux of where we stand. So, as we draw this discussion to a close, my position remains that this seizure represents an egregious federal overstep. It was built on a defective, misleading affidavit that omitted vital exculpatory context, and it relied on witnesses with documented biases. By utilizing expired misdemeanor statutes as a fishing net to justify seizing the only original copies of a county's election records, the federal government has severely compromised state sovereignty. It has broken the chain of custody necessary for state audits, and it centralized highly sensitive voter data in a way that profoundly damages voter trust.
And my summary really rests on the mechanics of the law, which is what Judge Boley was bound to follow. Despite the warrant's acknowledged flaws, the strict legal standard of callous disregard protected the federal government's ongoing mandate to investigate. An imperfect affidavit is not automatically an unconstitutional one. The federal government possesses a compelling, superseding interest in ensuring federal election laws are not violated. And because the Department of Justice provided full, verified digital copies to Fulton County, the county avoids the irreparable harm necessary to force the return of the physical evidence. The investigation, uncomfortable as it may be for the state, must be allowed to follow the facts.
Yeah. Well, we clearly diverge on the ultimate legality of the seizure. I think we have to agree that Judge Booley's characterization of the FBI's affidavit as misleading and troubling is a massive concern. I mean, when federal agents omit critical context regarding something as fundamental to our democracy as an election, it rightfully invites intense scrutiny from the public.
Oh, I absolutely agree with you there. Law enforcement must be held to the highest possible standards of candor, especially in matters of democratic administration where public trust is just so fragile. We also converge on the reality that the tension between federal investigative authority and state-run elections is an incredibly delicate balance. Every action taken by either sovereign echoes loudly in the minds of the voters.
It really is a vital reflection on how procedural legal standards like the high Jenga tower bar of Rule 41G ultimately dictate the balance of power between local election administrators and federal investigators. As this federal probe continues and as we see how these sweeping subpoenas for poll worker data actually unfold, there is much more to monitor in the source material.
There certainly is. The legal mechanics of how we resolve these disputes won't just impact this case, they will shape election law and federalism for decades to come.
Yeah. We began today by talking about the zip tie seal on a ballot box, a physical promise of state protection and chain of custody. Today, that seal sits broken in a federal warehouse. The question that remains is whether breaking it will ultimately illuminate the truth of our democratic process or permanently fracture the trust required to sustain it.